Okay, let's dive right in. We're about to explore one of the weirdest, most fascinating corners of contract law. It's called the doctrine of mistake. And yeah, it's exactly what it sounds like. A place where one simple slip-up, one tiny error, can literally blow up an entire deal.
So imagine this for a second. You save up, you splurge, you buy what you think is a priceless painting, an original masterpiece. But then you get it appraised and the expert tells you, sorry, it's a fake. A really good fake, but still a fake. So, is the deal still on? Are you just out of luck? Well, the law has something to say about this, and trust me, the answer is not what you'd expect.
So here's how we're going to tackle this. We'll start with what makes a mistake fundamental in the first place. Then we'll look at the shared delusion, when everyone's wrong. After that, the one-sided error, and my personal favorite, identity deception. Finally, we'll zoom out and see how this is all just one big legal balancing act.
All right, first things first, and this is super important. Not every mistake gets you out of a contract. Not even close. You can't just get buyer's remorse and say, oops, I made a mistake. The law is way more specific than that. A bad deal is, well, it's just a bad deal.
The magic phrase here is operative mistake. This isn't about the price or the value or wishing you'd gotten a better bargain. No, an operative mistake is an error that's so deep, so fundamental, it hits the very core of the contract. It's like the whole agreement was built on quicksand. And if a court finds an operative mistake, it basically says, you know what? This contract never really existed to begin with. Poof, gone.
Okay, so this is where it gets really interesting. What happens when both people in the deal are wrong? Like completely, totally wrong about the same thing. This is what lawyers call a common mistake, but I like to think of it as a shared delusion. The whole contract is based on something that just isn't true.
The textbook case for this, the one every law student learns, is an old one called Couturier vs. Hasty. Picture this. A guy agrees to buy a shipment of corn that's on a boat somewhere at sea. Another guy agrees to sell it. Sounds simple, right? The only problem, unknown to either of them, the corn had already gone bad on the voyage, and the captain had sold it off. It didn't exist anymore. So the court looked at it and said, well, the contract is void. It's just common sense, really. You can't buy or sell something that isn't even there.
But wait, it's never that simple in law, is it? Fast forward about 100 years to a case called McRae v. CDC. A company pays for the rights to salvage this shipwrecked oil tanker. They spend a ton of money getting their crew and equipment out to the middle of nowhere, only to discover there's no tanker. There's not even a reef where the tanker was supposed to be. So, same situation, right? Wrong. This time the court said the contract was valid. Why? Because the seller didn't just think the tanker was there, they promised it was there. That wasn't a mistake, it was a breach of contract, a broken promise. So they had to pay up.
And you can actually see a trend here. Over the 20th century, the courts got tougher and tougher on this. They really wanted to make sure business deals were stable. So first, in Bell v. Liver Brothers, they decided that a mistake about the quality of something wasn't enough to void a deal. And then, much more recently in 2002, a case called the Great Peace set the bar incredibly high. Now, for a common mistake to void a contract, it has to make performing the deal literally impossible. That is a very tough hurdle to clear.
Okay, so that's when both parties are mistaken. But what if it's just a one-sided thing? This is called a unilateral mistake, and it's a whole different ballgame. It's when one person makes a big mistake and the other person knows it. They see the mistake and think, aha.
And the classic example here is just fantastic. It's a case called Hartog versus Collin and Shields. A seller was trading hareskins, and in their offer, they accidentally priced them by the pound instead of by the piece, which was the normal way to do it. This made the skins ridiculously, unbelievably cheap. The buyer saw this obvious typo and tried to snap up the offer. But the court basically said, no way. You knew that was a mistake. You knew what they meant. You can't just take advantage of someone's obvious blunder like that. There was no real agreement on the price, so the contract was void.
All right, now we get to the really juicy stuff. The con artists, the rogues. This is where mistake gets all cloak and dagger. We're talking about mistakes of identity, where someone pretends to be someone they're not to trick you into a deal. And the real dilemma here isn't just about the original victim, it's about what happens next. Because the rogue usually sells the goods to some innocent person. So now you have two innocent victims, and the law has to decide which one bears the loss.
And man, the courts really wrestled with this for a long time. You can see them going back and forth, case after case. The whole thing hinges on a tricky legal distinction. Was the contract between the owner and the rogue void or voidable? If it's void, it's like it never happened, and the original owner gets their stuff back no matter what. If it's voidable, it's valid until the owner finds out and cancels it. If the rogue sells the stuff before that happens, the new, innocent buyer gets to keep it. As you can see from these cases, the decisions were all over the place for a while. It was a real legal tangle.
But eventually, the law settled on a clear rule, thanks to a case called Lewis v. Avery. And the rule is this: when you're dealing with someone face-to-face, the law assumes you intend to deal with the person standing right in front of you, even if they're a liar. So the contract is real, it's just voidable because of the fraud. What does that actually mean? It means if the con artist sells your car to an innocent buyer before you realize you've been duped and call the police, that innocent buyer gets to keep the car. It's a harsh result for the original owner for sure, but the idea is to protect innocent buyers and keep business flowing.
And that really gets to the heart of what this is all about, doesn't it? The entire doctrine of mistake is this giant, complicated balancing act. On one side, you have fairness, trying to protect someone who made an honest, fundamental mistake. On the other side, you have certainty, the idea that contracts need to be reliable for our whole economy to work. And as you can see from all these cases we've talked about, this wasn't figured out overnight. We're talking about a century and a half of legal battles, of judges trying to draw the line in just the right place. It's a long, winding road to get to where we are today.
Okay, so what are the big takeaways here? First, a mistake has to be huge, truly fundamental for it to matter legally. Second, the law has your back if someone tries to knowingly take advantage of your slip-up. No snapping up allowed. But, and this is a big but, courts really, really don't like to void contracts. They value stability. And finally, in those messy fraud cases, the law often sides with the innocent third-party buyer, even at the expense of the original owner.
And that brings us to a really fascinating and kind of scary final thought. All these rules about dealing by mail versus face-to-face, they were invented in the 19th and 20th centuries. So what happens now? In an age of AI deepfakes, of online anonymity where you never really know who you're talking to, how do these old rules hold up? Is there even a difference between face-to-face and at a distance anymore? That is a massive question, and it's one the law is going to have to figure out, and fast.